Welcome to Client School. I'm Brian Godfrey, a legal assistant with Utah Family Law, LC.
I'm Eric Johnson. I'm a lawyer with Utah Family Law, LC, and today we're going to talk about the 2016 legislative session and the family law legislation that's being proposed. Now remember, when we make this, it's February 2016, and these are laws that are proposed and have not yet been passed into law, some of which may be passed, some of which may not. But we wanted you to know about them because if they do become law and end up benefiting you, you'll want to use them. If they end up becoming law and they end up working to your detriment, you're going to want to be aware of this sooner than later. All right. Brian, let's talk about the first one, which is rather interesting, and that is for people that don't know, when you're going through a divorce, you are required, if you have children, to attend two classes, the divorce orientation course and the divorce education course. This is a total of 3 hours, and up until recently, you had to attend the divorce education course in person for a total of 2 hours in designated places where this class is held, and you only could go there. You have to pay $55, if I remember correctly. All right. Well, I have been a vocal critic of this, saying this is crazy, people are busy, and this class, although it may be well-intentioned and even rather interesting, is not essential to make sure that parents don't become delinquents once they divorce. Now, there are other people that will tell you what a wonderful thing this course is and how it's absolutely essential that every divorcing parent of minor children take these classes. They are welcome to their opinion, but if I had my way, I would put them online. Well, one of the legislators has also agreed this would be a good idea, and so it's House Bill 66, the online parenting course for divorcing families bill, which would authorize courts to provide an online option for the mandatory education course for divorcing parents.
Yeah.
So, if you think this is a good idea, if you've been through it and don't want to see other parents have to go through this course, even if you liked it but thought it was inconvenient, you may want to let your legislators know. Not just the sponsor of this bill, who is Carol Spackman Moss, but also your legislator in your district. Okay, the next bill we want to talk about, House Bill 128, alimony amendments. This is a terrible bill, which has been voted down many times. But essentially what this is saying is that this is from Kevin Stratton. He's the sponsor, would provide that the court shall consider whether a parent has lost workplace experience opportunities while caring for a child as part of a marriage. And as a result of this, the bill provides that the court will consider whether a parent has lost workplace experience opportunities while caring for a child when determining alimony. Brian, how many people do you know who have lost workplace opportunities as a result of having children?
Zero.
Why is that? Now, wait a minute. Do you hear what this man just said? Are you telling me that when people have kids, that doesn't limit their career opportunities?
No. What I'm saying is they made a choice to be an at-home parent and take care of their kids, and so they forego the opportunity to work somewhere.
Exactly.
Because they want to take care of their
So
family.
unless you could show that you were forced to get pregnant and have a baby and take care of it, or you as the man who were forced to take care of a child that you didn't want to take care of, then only then would you be able to say, I lost workplace opportunities because of caring for children. Nobody forces people to have children.
Or to make them.
Yeah, that's what I'm saying, to have children and to take care of them. And if you decide to bring a child into the world or take the risk of conceiving a child, you didn't lose workplace opportunities because of your child. You lost the opportunity because you chose to conceive or run the risk of conceiving children. That's why, there are many other reasons not to like this bill, but that's the main reason. Because what this is really aimed at is, let's be honest, it's still, as of 2016, most of the people that are full-time caregivers of children or stay-at-home parents are women.
Right.
Okay. So far, except unless you count that one guy or that woman that got a sex change and then got pregnant anyway, only women can bear children. So what's going to happen here is women are going to say, I had 2, 3, 4, 5, 6, 12 children, and as a result, I had to stay home and take care of them. No, you didn't. You chose to have those children. And then you say, well, we agreed that I would stay home and that my husband would... Now, by the way, am I biased against women? No.
No, the same argument can be had if I was a man.
Right, but we're saying that the fact is most of these are going to arise in the case of a woman and a mother seeking alimony, okay? And just say, no, look, nobody forced this upon you, okay? So you didn't lose workplace opportunities. You didn't lose them. You, as you said,
Right.
you forewent them.
Right.
You said, look, I'm going to have kids. I realize by having children that
Right.
my choice to
Yeah.
have children will limit my workplace opportunities, but that's okay. I'm trading that opportunity for the opportunity to be a parent.
Right. I'm not upset that as a parent, as a man, that I can't go fly around the country and fix F-16s because I want to be at home to help raise my family,
Yeah,
be around
to be
my
a good
kids.
example, to help with
Right.
homework, to
be a
teach
dad.
teach
Sure.
your kids how to be mature, all that kind of stuff. So anyway, enough said on that. Anyway, and reasonable minds can differ, but the most reasonable people will agree with me.
Right.
All right. House Bill 148, Protective Order Amendments. Now, there are a couple of these going on, but this one is sponsored by Angela Romero, which would modify protective order provisions by amending dismissal of protective order provisions. Specifically, it would make it a law that if a divorce proceeding is pending between the parties to a protective order action, so this is two things. Couple is getting divorced, and there is also a separate protective order action in court. Those are two separate lawsuits, okay? The protective order would then have to be dismissed instead of may be dismissed when the court issues a decree of divorce if the petitioner in the protective order action is present or has been given notice of both the divorce and protective order action that this is happening, this dismissal is going to occur. If the court specifically finds the order need not continue after making specific findings on each factor that would go to the dismissal, and then determines the petitioner no longer has a reasonable fear of future abuse, and if the court informs the petitioner of the effective dismissal. Not a bad thing. I mean, frankly,
Right.
it's not really going to. It's making some minor changes. Pretty much, you could do that anyway. But this is making a clarification. Not a bad thing. All right, the other one, falsification of information in a protective order proceeding. As everybody knows who is intellectually honest, there is a lot of fraudulent protective order filings, allegations for protective orders. I'm not saying, you're not saying, that there are not legitimate
There's
protective
some that are
orders.
very legit.
There are
Yeah,
people
need
out there.
protection,
Yeah,
but
there are
getting
people who are the victims of domestic
Sure,
violence.
Sure.
Men, women, and children who are the victims of domestic violence,
Sure.
and protective orders are a boon to them.
Yes.
There are also opportunistic people out there who will accuse a spouse or a boyfriend or girlfriend of domestic violence to get a leg up
Yep.
in a divorce or child custody case, to get leverage, all sorts of things. There are a lot of people that will deny it, but the reason they'll deny it is not because they know it's false or believe it even to be false. It's because they are so invested in protective orders and having them be as easily obtainable as possible that they deny that there's any kind of abuse. You could be filling out a protective order form and telling this advocate, it's like, oh, by the way, I'm lying through my teeth.
Right.
I am seeking a fraudulent protective order. And that person would say, no, I've never heard of such a thing ever happening. All right. So keeping that in mind, it's been very hard for years and years. People have tried to say, look, protective orders are a necessity when they're warranted. Protective orders benefit people and do offer protection, but there needs to be protection from fraud. There
Yes.
needs to be, you can't use protective orders as a sword, just as a shield. So this Senate Bill 90 by sponsor Dixon Pitcher, sorry, no, that's not the right one. Would amend provisions relating to protective orders and child protective orders when a petitioner knowingly provides false information. This bill would provide that a respondent may bring a petition to allege the petitioner knowingly falsified a material statement or statements or material information for the purpose of obtaining a protective order or child protective order, and requires the court to penalize a petitioner who knowingly falsified a material statement or statements or material information. It's about time.
Yeah.
Now,
Yes.
here's the argument you'll hear. Well, if we make it so that people get punished for filing false protective order claims, it might have a chilling effect. People might be afraid to come forward.
No.
Frankly, I've never understood that.
Yeah.
Because it's not as though, if you come in with a black eye after the police had to pull your boyfriend or girlfriend off of you because he was beating the hell out of you, or she was,
Yeah.
and you seek a protective order, you're going to win. Okay? And if there's not a mark on you, but you've got this devious significant other who's terrorizing you all the time and you don't have any proof, well, frankly, it's high time that the courts didn't just err on the side of caution and instead said, look, it may very well be true that you're being terrorized and being threatened within an inch of your life, but there's no evidence other than your word against his or hers. That's not fair. That's not a preponderance of evidence. But what's happening, and the courts deny it, but it's as plain as the nose on your face, is they're taking the safe approach. They're acting out of an abundance of caution and saying, well, gee, what are they doing? I don't want to be the one who turns down a protective order request and then have that
Somebody
person
gets killed.
end up killed the next week. So what they're doing is they're not doing their jobs. They're just being cautious and saying, well, if anybody asks for a protective order, I'll grant it. It's devastating the lives of innocent people. They're losing their jobs, they're losing their ability to own a gun, and thus, if you're a security guard or a police officer, you lose
like the Second
you lose your job.
Amendment, right?
You know, people in your community, your church, your volunteer organizations, especially if you take care of kids and things like that, if you're a school teacher, it ruins lives. And people say, oh, well, it's all worth it if it protects one person. No, it's not.
Not when it's
No,
false.
it's not. Well, I mean, even if there are a few deserving people that fall through the cracks because they're afraid, it's like, I don't have any evidence. I can't prove I'm being terrorized. You have other options, but there's just so much. I mean, you've got statistics, FBI, all kinds of other statistics from various organizations showing that in some cases, in fact, most cases, as far as I'm aware, the majority of protective order requests are fraudulent.
7 out of 10 was one study.
Yeah, it's got to stop, and it's fine. It's high time we put some teeth into these statutes that would make it so that if people are going to, because right now there's no penalty for lying.
Right.
File a false protective order.
When it's more than half, it's pretty obvious that it's being abused.
Right. So file a false protective order. You may not win the protective order. You may get it dismissed, but you won't get punished. So why not do it?
There's no incentive not to.
Exactly.
You're not going to be held accountable, even though there is some wording in there that there can be some jail time. It's just never enforced.
Another interesting bill that probably won't have much effect on anybody, but would be interesting to note because of the recent legalization of gay marriage in Utah and the country, is House Bill 299. What that does is that changes the wording in the Utah Code governing marriage and divorce, because we used to refer to husband and wife.
Right.
That was all there could be. There could not be husband and husband or wife and wife. So we would always talk about husband and wife. We would always talk about the husband being the man or the woman being the wife, as opposed to two wives,
right.
Two women, two husbands. So they're simply changing the genders so that we can recognize gay marriage and not simply treat marriage as a purely heterosexual union. So that's kind of interesting. We hope that you found that useful. This is, again, a 2016 legislative review of proposed legislation. We will keep you updated as to what passes the House and the Senate as they go along, and we'll even let you know eventually in March what bills were signed into law, so you'll know what has changed and what the face of Utah family law has become as a result of the 2016 legislative session.
And we'll refer to this video to make sure that we covered the ones that didn't make it, that maybe should not have made it as well.
Thanks for coming to Client School.